Good morning, everyone. Thank you so much for being here. My name is Elizabeth Wydra. I'm president of the Constitutional Accountability Center. And I am delighted to welcome those of you who are here and those of you who are watching on the live stream to the National Press Club for CAC's 5th annual home stretch at the Supreme Court. Back in April 2014, we at CAC were talking about how it would be great to have a new Supreme Court event. As many of us know, there are many great panels about the court at the beginning of the term in October, and after the term has ended in end of June, beginning of July. But there wasn't anything that sort of came in this moment when we've just finished oral arguments, but we have to look forward to most of the big decisions. And it's really a good moment to think about what has shaped the term thus far. And even though Supreme Court observers hate making predictions, maybe wrangle some predictions out of our experts on the panel. And so, while there are a lot of things you can't predict, I think none of us predicted President Donald Trump 4 years ago. Certainly your attendance today is testimony that we were right about the need for this event. A conversation about the court and its incredibly important work is timely and productive at this point in the term, and we're very glad that you can join us once again this year. Now, if you've been to this event before, I feel like I say this every year, and I really do mean it, but this term is a blockbuster. If this were Saturday Night Live and I were Stefan, I would say it has everything. Partisan gerrymandering, President Trump's Muslim travel ban, equal treatment of LGBTQ Americans in the public square, purging of voter rolls, the future of public sector unions, cell phone privacy, free speech and abortion access. The sweep of this term is simply breathtaking. And for those of us who either work in or cover the Supreme Court, I think it has taken our breath away a lot of times. It's even hard to imagine, given how slowly the court has been working through its docket, simply the crush of momentous decisions that are going to come down in the month of June. I can't even picture standing there sweating it out on the plaza with many of you as we get decision after decision after decision in these huge cases. But, we made it through the terms on the Affordable Care Act, Section 5 of the Voting Rights Act, marriage equality, and so somehow we will muddle our way through this term as well. But it's going to be incredibly exciting and important. Now, if the subject matter of the term weren't enough to make it a blockbuster, this term also places at center stage the careers of two justices, Justice Kennedy and Justice Gorsuch, the court's longest-serving member and its rookie. As I noted in October, Justice Gorsuch, newest to the court, could benefit from watching and emulating his mentor and former boss, Anthony Kennedy. As you might remember, on the heels of his victory lap with Senator Mitch McConnell in Kentucky and then speaking at President Trump's hotel here in D.C., last year Justice Gorsuch sent an unfortunate message that he was not particularly interested in even appearing impartial or above showing partisanship. Add to that his early penchant for lecturing his new colleagues, both from the bench and in his opinions, and the stately deportment of Justice Kennedy stood in stark relief to that of the rookie justice. Looking back on the oral arguments of this term, it seems like Justice Gorsuch seems to have gotten the message and seemed to have been a little more humbler, more of a humble justice, more like Justice Kennedy this term. Now, even as Gorsuch has lived up to the business community's highest hopes for him, voting with the U.S. Chamber of Commerce in 9 out of 10 cases at this point, Justice Gorsuch seems to have checked the behavior that contrasted so sharply not only with the justice for whom he once clerked, but also with the court's Chief Justice. John Roberts has taken great pains to lift the Supreme Court out of the partisan fray, to improve its standing with the public, even if some of us might think he has not always succeeded in that endeavor. But President Trump's Muslim ban being before the court certainly does not make the job of making the court seem non-political any easier. The day before Donald Trump was inaugurated president, Rich Wolf's headline in USA Today asked whether Chief Justice Roberts will be Trump's friend or foe. That question holds for Justice Gorsuch also. And the answer, of course, should be neither. To the degree Gorsuch follows the Constitution and the text of the law, rather than a selective originalism that allows him to reach outcomes he already agrees with, then he will be an independent check on Trump's unconstitutional, outrageous, and unprecedented behavior. Topping that list, of course, is this president's multiple attempt to ban immigrants, students, siblings, spouses, parents, refugees fleeing civil unrest from entering the country based solely on his animus for their religion. In short, Trump's Muslim travel ban is a major test for Gorsuch as Trump's first justice. Gorsuch didn't tip his hand very much at yesterday's argument, as those of us who were there saw, but either way, we'll have to wait until June to see whether Gorsuch passes this big test. Meanwhile, we can look at an unexpected vote that Gorsuch cast this month in a deportation case. That he and Justice Thomas disagreed on the text and history underlying the court's vagueness doctrine, applying the Constitution's due process guarantees, is an early data point in evaluating Justice Gorsuch's fidelity to the whole Constitution. As many have noted, myself included, we should be cautious about overreading or misreading Gorsuch's vote as somehow being a support for immigrants in general. But ultimately, he had the better of the argument about the law in that case. And when Gorsuch is right, even his critics, like me, should say that he's right. So this is me saying he's right. I don't know if it'll happen very often, so we're going to remember this moment. Now, we're going to see some other tests of Gorsuch's commitment to his originalism. If, for example, Justice Gorsuch believes that the Piggy Park case was correctly decided. This was a case, of course, that rejected a restaurant owner's desire to discriminate against Black customers, justified by, he claimed, his sincerely held personal religious beliefs. Then Gorsuch's vote in the Masterpiece case, following this precedent, should be straightforward. The 14th Amendment's guarantee of equality is now, fortunately, the bedrock of our Constitution. If the court was right in that case to reject the restaurant owner's plea to racially discriminate, then rejecting a baker's plea to discriminate against gay and lesbian Americans for personal religious reasons should be rejected just as quickly. Now that leads us, as it often does, to Justice Kennedy. His views in cases like the Masterpiece case, the partisan gerrymandering case, are characteristically expected to be decisive. Basically, it's Justice Kennedy's world, and we are all just living in it. But how long will it be Justice Kennedy's world? Last year from this podium, amidst a swirl of rumors about his potential retirement, I argued that Justice Kennedy himself is the best steward of his legacy, and that has not changed. Kennedy has already hired his clerks for the next term, which has calmed the rumor mill a little bit, but not entirely. And while only he knows his mind at this point, it still makes little sense for him to hand off his legacy, to hand off his life's work to a president so erratic and chaotic, facing multiple investigations, disdainful of courts and judges who disagree with him, with a checkered judicial nomination record that includes ghost hunting, Klan-defending bloggers, and a guy who once wrote himself that Kennedy was a judicial prostitute. I don't even know what that means, but I don't think it was meant as a compliment. Instead, and entirely apart from his legacy, I believe that Kennedy values the court as an institution as much as the Chief Justice does, and therefore will be loath to hand off his legacy and the role of the court to this president. Creating a vacancy today in this toxic environment would place the court directly in the middle of partisan politics in a midterm election year, and Kennedy's critical fifth vote would be put in the hands of perhaps the least competent president in our modern history to manage and value it. So let me close today by noting that the Constitutional Accountability Center was founded in 2008, and I am pleased to say I was present at the creation. And that means that here in 2018, we are celebrating the 10-year anniversary of our work promoting the progressive promise of the Constitution's text, history, and values. We have filed more than 150 briefs in that time, including more than 100 in the U.S. Supreme Court, representing clients ranging from criminal defendants to conservative and liberal academics to members of Congress and state legislators from both parties. I encourage you to visit our website to see more about our work in this 10th anniversary year at our brand new fancy website, which I'm really proud of, theusconstitution.org, and learn more about our briefs, our think tank work, and our judicial nominations work. And now, I could not be more proud to kick off our 5th annual home stretch event by welcoming the fantastic moderator of our wonderful panel today. Ari Melber, of course, needs a little introduction, but I will say that he is MSNBC's chief legal correspondent and NBC News legal analyst, and the host of The Beat with Ari Melber, his fantastic show that airs nightly at 6 p.m. Eastern on MSNBC. Thank you so much, Ari, for leading the discussion today. It's all yours.
Thank you. Thank you very much, Elizabeth. And let's get right to it, because so much in this town is noise, hype, and lies. So it's very exciting to be with some factual legal people and really dig into the substance of some of these cases this term and where we're headed. Kristen Clarke is from the Lawyers Committee for Civil Rights Under Law. John Elwood, Supreme Court litigator at Vinson Elkins. Brianne Gorod is also with the Constitutional Accountability Center, a colleague there. And Ajmel Quereshi, NAACP Legal Defense Fund. And we're going to begin with Gorsuch, who's now making moves, as we say. He's in it, and he has been in many ways on most votes similar to the seat he filled. Where do you see his role in the court?
Good morning, and let me just first start off by thanking Elizabeth for her leadership and the Constitutional Accountability Center for their most important work, helping to ensure that we have a society that is faithful to the Constitution and its ideals. So we are about a year into Justice Gorsuch's tenure on the Supreme Court, and while some may say that the verdict is still out, I think that there has been much evidence over the past year that suggests that Justice Gorsuch is someone who is deeply aligned with Justice Thomas. We've seen the two closely aligned at a number of occasions with very rare exception. But Justice Gorsuch did throw us a curveball very recently in a case in which he sided with 4 justices in striking down a law that had allowed the government to deport immigrants who commit, quote, serious crimes because he deemed the law constitutionally vague. And this decision is an important one. It's one that will make it more difficult for the administration to deport people who have convicted some kind of crimes. It takes the wind out of the sails of their efforts to use this law as a tool for deporting people en masse. Justice Gorsuch is somebody who likes to ensure that people are on notice about what laws prohibit. So I think this was an interesting ruling. It's one moment of departure, and we'll have to see how that bears out over time. That said, the originalists are singing Justice Gorsuch's praises, and I'll share some commentary from a few from the originalist camp. Mike Rappaport is somebody who feels that the evidence suggests pretty strongly that Justice Gorsuch is no Justice Souter or Chief Justice Roberts and could be another Justice Thomas. He deems him a strong originalist based on his comments at oral argument, but seems to be very pleased with his first year on the court. The Patriot Post is a blog that deems Justice Gorsuch's behavior so far to be, quote, very promising. So I think in terms of the originalist camp and the Federalist Society and folks who have been really pushing to shape the kind of scope and tenor of a lot of the nominees that have been put forth by the president, they're pleased with Justice Gorsuch and are probably hopeful that there'll be many folks like Justice Gorsuch who are put forth for the remaining district and circuit court nominations that remain. Other observations. There has been some controversy. Elizabeth mentioned one of Justice Gorsuch's appearance at an event at a Trump hotel that raised eyebrows. I thought it was interesting observing Justice Gorsuch during the State of the Union. There was a moment where President Trump really held Justice Gorsuch out as part of his agenda for reform. He talked about how he is moving forward at appointing judges who will interpret the Constitution in this originalist tradition. And he kind of wove Justice Gorsuch into this narrative about how he is approaching reform in this era. The cameras panned to him during the State of the Union, and he was very stoic, very ice cold. At some point, Justice Kagan kind of leaned over to probably tell him to loosen up a little bit. I wonder if that's a moment where he's trying to signal to the public that he will be independent, but I think that there are a lot of questions that loom about whether Justice Gorsuch is there to carry forth the president's agenda, and some questions in the public's mind about whether he can truly be fair and independent in hearing the cases that come before him, or is he there to execute an agenda? So all of these questions loom, and at the end of the day, though, I think that the verdict is clear. This is a judge who is very much of the Justice Thomas ilk.
I'm in the camp that it's still a little bit early to tell. As Justice White is purported to have said, and I'd love if anybody could tell me where this is in print. With every new justice, it's a whole new court, and it remains to be seen what the dynamic is between them. Because remember, in the old days, we had the Scalia-Souter footnote wars where they would just not give it up. And that kind of affected things. It slowed opinions down, and it created a whole lot of dicta and footnotes. It's too early to tell what's going to happen with that. It does appear that he is an independent voice, and that just in the last couple of weeks he's split off from Clarence Thomas twice on separation of powers issues, and they've been in different blocks in the Sessions versus DiMaia case and Jesner versus Arab Bank. And he does write a lot of separate opinions. I don't know that he's to be faulted for that. Justice Stevens wrote separately a lot. Justice Stevens was super fast. And I think we'll figure out over time whether or not some of the slowness of the court in getting opinions out has anything to do with the fact that he's written so many separate opinions, or if it's something else. But we'll have an answer in another 5 years or so, I think. So, but it's an interesting thing to see, and I thought the Sessions versus DiMaia was a very thoughtful and interesting opinion. It reminded me a lot in that regard of Justice Sotomayor's separate opinion in the Jones case, which was electronic surveillance, just in that it looked at things in a different way, and you had sort of the sense reading it that this may affect the terms of the debate going forward. And I think it might. It also shows, I think there are a couple things that are interesting in the Sessions versus DiMaia opinion. It was very sympathetic, I thought, to aliens who are present in the United States. Regardless of whether he said, regardless of whether they had any right to be there, to get in, now that they're here, they have some rights before they're booted out. And also, it seemed to take a very kind of broad view of separation of powers and what decisions have to be made by legislatures as opposed to courts. And it'll just be interesting to see where he goes with that and how many takers he gets for that view. Because remember, Scalia was a lone voice on a lot of things when he arrived at the court and achieved a fair amount of consensus over the decades he was on the court.
Yeah, I mean, it obviously is, still quite early. But a year in, I think, what the evidence so far is that Justice Gorsuch is very much, I think, the justice he seemed like he would be when he was nominated and confirmed, an extremely conservative justice, one who's not at all shy about advancing his own view of the law, even if that differs from the views of his colleagues and even the views the court has expressed in its past precedents, and one who I think also takes a long view of the law. I think it'll be really interesting to see, where he goes from his separate opinion in DiMaia v. Sessions. It was a very important decision in its own right, but in his discussion of the vagueness doctrine, he kind of laid the groundwork for using that doctrine to strike down, not only criminal laws, which has been its normal context, not only immigration laws as here, but also a whole range of civil laws. And so, I think it'll be really interesting to see, where he takes it. It was another immigration case on the 10th Circuit where he laid out his view that, it might be time for the court to reconsider Chevron, which is a bedrock doctrine of administrative deference. And so this may well be an example of him setting out here kind of where he wants to take the law. I think it's also the case that, I think a great example of kind of his conservativeness is, as Elizabeth mentioned in her opening remarks, the court's business docket. I mean, that is an area where the business community, I think, was positively gleeful when his nomination was announced. They said it was a fantastic nomination. They predicted it would return the court to its pro-business leanings, and that's exactly, what we've seen from his votes thus far. As Elizabeth mentioned, and I think, this case that was decided at the beginning of this week, Jesner, an alien tort statute case, which we'll probably talk about a little bit more later, is a prime example where, if one had followed just the text of the statute, of the law, I think it is very clear that he should have come out the other way, but instead he, voted in the way that is pro-corporate, that immunizes corporations from liability for really shocking human rights violations. And then I guess the third thing I'll say is I think the jury's really still out on him as an originalist too. The question isn't, whether he's, the problem isn't, being committed to the text and history of the Constitution. Of course he should be. The question is, where that commitment leads. And I think, as Elizabeth mentioned in the opening, there are some real tests of his commitment to the text and history and values of the Constitution that are still outstanding. And I think the travel ban case, we probably won't get a decision until June, is a really prime example of that. If he follows the text and history and values of the Constitution, he should vote to strike down the ban. But will he do that? Or will he simply rubber stamp this policy of the president who appointed him? So I think there's still a lot of questions, but also some really strong indications of where this justice is going to be.
Thanks so much to each of you for attending today, to my colleagues, the Constitutional Accountability Center, Elizabeth and David, for organizing the event. A lot of what I'm going to say is going to be somewhat repetitive of what's been said already, but I'll try to...
You don't have to do that. You could just do your new part.
Do my new part?
Yeah.
All right, my new part is this. As someone has said already, he's sided with Justice Thomas quite a bit. I'll add a number to that. In the first 15 opinions from the court while he was on the bench, he sided with Justice Thomas in each one. By contrast, he clerked for Justice Kennedy, and he sided with Justice Kennedy only 73% of the time in those first 15 opinions. He was a very vocal question asker. He asked 21 questions during his first oral argument, which was more than any of his other 8 colleagues. He certainly has a broad conception of religious liberty. I think if you look at the Trinity Lutheran case and his separate concurrence, that was the case having to do with funding for playground equipment for a religious school. He separately concurred to make the point that the religious liberty conception that he was putting forward was broader than the one in the majority. He also certainly, as has been mentioned already, is skeptical of agencies acting with legislative authority, essentially agencies doing the actions that Congress is doing. And so those are some main points that have jumped out to me from Justice Gorsuch's early work.
And we'll stay on you to kick off. Now we'll turn to immigration. Obviously, this DiMaia case has gotten mentioned as a little bit of an outlier, but thinking about that, the detention policy case, and of course yesterday's travel ban case, your views of the court weighing in on immigration, which has become something that, while Donald Trump is widely criticized for a lot of valid reasons, I think it's fair to say his views on immigration and trade tapped into real things that people at least felt around the country that were largely missed by both political parties and the leadership across Washington. He also tapped into racism, which remains very popular. So the fact that you're tapping into something that is out there doesn't mean ipso facto that it is a great thing. But I wonder about that backdrop to the court going right into immigration issues, 2 of which relate to the very hard edge policies of this new young president.
So I actually see the three of them as very different cases. This is the Trump travel ban or the Muslim ban, Damaya, which was the case having to do with deportation for people who have been convicted of quote-unquote crimes of violence, as well as Jennings v. Rodriguez, the case having to do with whether or not individuals who have been in prolonged immigration detention are entitled to bond hearings, essentially hearings determining whether or not they pose a flight risk or a danger to the community. And I'm going to address each one of them separately, and I'll go with Damaya first. I think in terms of legally, I think of Damaya as a fairly straightforward case. There was a case, Johnson, that was just a couple of terms earlier, in which the court looked at a similar term in federal law and said, it is also vague. And so I think legally it's a fairly straightforward case based on this other case, Johnson, from just a couple of terms ago. I think what is interesting is the separate Gorsuch concurrence, which applies a very strict definition of whether or not something is vague, and it sends signs for the future as to essentially how much power agencies will have and whether or not Congress delegating responsibility to an agency is being vague. And so I think it's interesting for the message that Justice Gorsuch is sending for the future as to what he's going to do with agencies who come forward who have broad legislative authority granted to them.
Well, let me push you on that and say, so the vagueness feels like a jurisprudential issue, and that's the way the judges dig into it. But as I understand it, the underlying reason it was there was that you had this administration going past what would have been the traditional definition of a violent felony to deport more people, which seems to come from an aggressive immigration deportation stance, no?
I don't think it's just this administration.
Okay, so
I think historically,
any administration, but basically the idea that Congress said you can get rid of people for violence. And
right.
that makes a lot of sense to a lot of people.
Well, I think
and then the prosecutorial discretion was used for things that weren't technically violent felonies.
Right, and that's essentially what was going on in this case. And I think that ties in really well your question to Jennings, which essentially had to do with the immigration system and people being in prolonged immigration detention for prolonged periods of time. And people are going to ask, why is this case important? Let me throw out a couple of facts and figures at you. Every single day, 20,000 people are placed into immigration detention. Between 2003 and 2017, 166 people died in ICE custody from medical conditions. The immigration deportation system costs taxpayers in America $2 billion every single year. So, of course, people being placed in deportation and whether or not they should get out when they've been in prolonged immigration detention is not just a matter of sort of shipping people out of the country. It's also an issue of taxpayer dollars and basic humanity when you look at the number of people who've actually died. But I want to go ahead.
Any other panelists on those two cases?
Well, one thing on Jennings, because Jennings just concerned bond hearings for detention, and Justice Alito for the court said, you can't construe the statute to require these kind of bond hearings. But there's a separate question about without the bond hearings whether the statute's unconstitutional, and that issue was briefed but not decided. And I thought that was interesting. Justice Breyer dissented from the bench and gave a very strong case, or he was clearly very heartfelt and stirred up about this, about how that was a constitutional violation, and it remains to be seen whether there's the fifth vote for that. But he should know what the answer to that already is, whether there is that fifth vote, and that's the next case. Oh, I mean, that case will be coming down the pike, I'm sure.
Well, the Muslim ban case I'd like to talk about.
Before we go there, though, on these two cases, strong moderator. Anything on these two cases, Brianne?
We're also excited to get to the Muslim ban.
So, it's hard to know where to start with the Muslim ban. It's been in the media for so long. And I think, I went back and looked at the government's brief yesterday, and I listened to the oral argument. And when you look at the government's brief in the case, over 2/3 of the brief is devoted to jurisdictional issues, which makes sense. If I was in their shoes, I would worry about the procedure as well. But I think it's important to go back to first principles. And I'm going to make that point a couple times today, going back to first principles. I think it's important to look at what was said initially by the president and his staff, because I think we forget about it. And so I don't often use notes, but I brought notes up here today because I want to actually repeat what the president said. Quote unquote, Islam hates us. We have allowed this propaganda to spread throughout the country that Islam is a religion of peace. Frankly, we are having a problem with the Muslims. Donald J. Trump is calling for a complete and total shutdown of the Muslims entering the United States. if elected, he would order the surveillance of mosques, and he would have no choice but to order the closure of some of them. And when asked whether there was a difference between requiring Muslims to register and Jews having to register in Nazi Germany, he responded, "You tell me." And so I think, we've heard these things. The campaign cycle has been going on for a while, and I think it's easy for all of us, even for someone like me who is Muslim, to forget about these things and gloss them aside, and as a lawyer, get lost in the jurisdictional issues. And that makes sense. The jurisdictional issues deserve to be litigated. But let's not forget what started this whole thing in the first place. So that was the first point that I wanted to make about the Muslim ban. The second point I wanted to make was that and this was made by former Solicitor General Katyal yesterday, who argued the case for the state of Hawaii, is that there are extensive screening measures already in place. And so essentially, if you take away this proclamation and the executive order that came before it and authorized it, it's not like, we will be defenseless. There's essentially the process that we've used of detailed, extensive vetting and screening on an individual case-by-case basis, which includes at least an 8-step process for refugees seeking residence in the United States, will continue to exist. That's the process we've used for over 100 years. It's worked, and we should continue to use it. And finally, I want to go back to first principles. I think, as a first-year law student, when I was a first-year law student, it sort of drilled into you to not use common sense, to just follow the law that is put before you, memorize the legal rules, and accept the legal rules because they are the law that you have to follow. But I think from time to time, it's good to step out of that idea that's drilled into all first-year law students and ask yourself, does something make sense from a common sense perspective? And I sort of looked about, and I thought about this as if I was explaining it either to someone who came from outer space or to my 5-year-old. And I said, if you were explaining our concept of religious liberty to either a 5-year-old or an alien who came from outer space, and you had to explain to them these 3 cases, would it make sense? So first, Trinity Lutheran, which essentially held that not providing funding to a religious school for playground equipment violates someone's religious liberties, essentially constitutes religious discrimination. So that's the first principle. The second principle is Hobby Lobby, the idea that a corporation's religious beliefs are violated when they have to pay a third party to perform a medical service. That violates somebody's religion. And then barring people from entering the United States after you've called for a ban, after you've said that Islam is not a religion of peace, after you've said that you're going to create a registry, that is not a violation of religious liberty. If the court finds, or if the court upholds and rejects the Establishment Clause claim, that essentially will be our doctrine, our law, as to what constitutes religious discrimination.
So let me bring in Kristen on that point. Ajmel makes the principled argument, but also presupposes that this is a textual Muslim ban. That's not what it says. And all of what the president had previously said can be flipped, as I think it to some degree was in oral argument yesterday, as running the other direction, because look at how much they talked about and promised and campaigned on, and then what you actually come up with is something that they would argue is much narrower.
Right. I think context matters. The oral argument yesterday, I thought, was simply breathtaking and remarkable that we have our United States Supreme Court in 2018 talking about naked religious intolerance in the way that they were. We have a court that loves hypotheticals. It was really interesting, I thought, when Justice Kagan and Sotomayor started to tease out this hypothetical about, a situation where you have deep, outright anti-Semitism and a policy that emerges from that anti-Semitism. And the question was presented to the United States, does it matter? Does the context matter? And the Solicitor General took what I thought is an indefensible position, that the President Trump was a private citizen when he made the statements that were just shared, that it doesn't matter. He took an oath of office, that he is now guided by smart officials around him who are steering him down a proper path, that this was a policy that emerged to protect our national security, we have to peel back the veil. And I think that when we do that, it's clear why today we have a Muslim ban 3 before us, a Muslim ban that is now before the court. And all of that context matters.
But when you each keep saying Muslim ban, I mean, what are you referring to? Because it's a ban on countries, right?
It's a ban on people coming into the U.S. from predominantly Muslim countries. And yesterday they tried to say, oh, no, that's not the case. The vast majority of Muslims around the world can enter the U.S., but when we look specifically at the facts before us, this is a policy that has a disproportionate impact on people trying to enter the U.S. from Muslim nations.
Does it legally matter for your case that the underlying animus in this theory is what created the ban, which is to say that if President Eisenhower banned several countries for whatever reason, maybe even a stupid reason, without that animus it would be okay, that the only reason you win under this theory is because of the campaign style of Donald J. Trump?
No, I think it's the context, which signals the intent, and it's the effect. When we look at how this is played out, it's clear that this is a policy intended to bar people from predominantly Muslim nations from entering the U.S. We submitted an amicus brief to the court in this case that was cited several times yesterday in the argument, in large part because we speak to two issues.
Just dapping you.
Oh, thank you.
You get it cited, that's always exciting.
The PARS equality brief. And what we do is we bring to life how this policy is played out. One of the things that the government tried to do yesterday is to say it's not an outright ban. There's actually a waiver process that people can take advantage of. And the reality is that just a few dozen people have managed to slip through the cracks and get a waiver and actually successfully enter the U.S. One of our victims in the case that was talked about before the court is a 10-year-old girl with cerebral palsy. Her father is a U.S. citizen, and he can't get her here to get life-saving treatment that he needs. There are tons of people who have tried to apply for waivers, and they've not been given an opportunity. People who've been told, you are denied, you've been denied a waiver, even though they never even got the opportunity to apply. So when we look at what motivated this law and how it's actually being applied in effect, to me the intent is clear. It is a Muslim ban.
So before we turn to democracy, for John and Brianne, were you surprised that the tenor of the arguments in court yesterday seemed to tune out a lot of the obvious animus and prejudice that really drove the 2016 election, and that Donald Trump has been very clear and on the record about it? And if so, does that reflect the Supreme Court's fundamental discomfort with those realities? And where do you see Justice Kennedy going?
Well, I mean, I think it's clear that a number of the justices were wrestling with how do we deal with these statements that were made by candidate Trump. Does this mean that the government could never engage in any kind of action that might have an impact on Muslims? And I think, Neil Katyal, in arguing, against the ban, did a really powerful job of making clear that the president not only hasn't distanced himself from the comments that he made as a candidate, he's doubled down on those comments. As president, well into his administration, when we were implementing this policy and its various iterations, he has, tweeted virulently anti-Muslim videos. His policy advisors have made clear that the subsequent iterations were just, attempts to tweak the first policy. He's at times said he wished that it could be the non-politically correct version of the policy. And I thought it was really powerful when, Neil Katyal pointed out that in his argument before the Ninth Circuit, he said that if the president had distanced himself from these statements and said, I take it back, it was wrong, that shouldn't be the basis for, policy in this country, and had implemented the ban, we might be in a different situation. But despite saying that, there's been nothing, since that argument by this administration to at all distance itself from the, anti-Muslim statements that candidate Trump, then President-elect Trump, and then President Trump have made. And I think, all of those statements taken together and that history and the context, does make clear that this ban is what it seems to be, a Muslim ban. And then,
Kennedy? What about Kennedy?
I think, Kennedy seemed like he was wrestling. He obviously picked up on the hypotheticals about, anti-religious animus. He also did seem concerned about making sure that, one defers to the president in areas of national security. But as, Kotshaw pointed out, there are obviously contexts in which you can't defer, and you can't defer to the president when his policies run afoul of the immigration laws, as they do here, and when they run afoul of the Constitution. There was a long history, as he alluded to at the argument, of in the colonies, the colonies using immigration restrictions in order to disfavor religious groups. And when our founders adopted the First Amendment, they adopted it to reject exactly that practice. And I know we want predictions here, and I think this one is difficult to predict. I think the justices were clearly wrestling with things, but I think they're going to find it very difficult to write an opinion that upholds this ban, given the restrictions in the immigration laws and given the principles underlying the First Amendment.
I think clearly several of the justices, including Justice Kennedy, had some worries about limiting presidential authority as a whole. They seemed at least interested in Solicitor General Noel Francisco's effort to say that that by interposing the cabinet and this process between the president and the action, that helped filter any animus out. And I think that may be, I suspect that the court will try to decide as little as they can in this case. And one of the ways of possibly doing that is to say, maybe there are record problems and send this back to the lower courts to consider and, then hope the whole thing goes away. And even that, though, will be somewhat of a limitation on presidential authority because they'll say the president can't just give his say-so. He has to paper the record. But it may be a way of making the decision a narrow one, and I think that'll probably be appealing to them.
We're going to turn to democracy, which Kristen's going to kick off.
Yeah, but if I can, I just want to say one last word.
You'll only be stealing from other things we're not going to have time to get to.
Okay.
Your call.
Solicitor General closed out his argument and talked about Islam being a great country. People make slips, but to me it's just so reflective of this administration's views towards Muslims and people of the Islamic faith. I thought that error yesterday was inexcusable. The
same guy did call Ginsburg O'Connor, even though O'Connor was off the court. So, anyway.
So there are incredibly important cases impacting democracy that are now before the court. 2 cases concerning partisan gerrymandering, a case concerning vote purging, and another case concerning discrimination in the redistricting context. The outcome in these cases will shape democracy in the years ahead and will have tremendous consequences for the upcoming 2020 redistricting cycle and implications for elections being carried out across our country in the midterm election cycle and beyond. So very much high stakes cases concerning the right to vote and democracy in our country. The partisan gerrymandering cases, I think, are an interesting one. I think that the Supreme Court agreed to hear the 2 cases now before it because they are finally at long last prepared to articulate some kind of standard to guide the efforts of officials who are redrawing district boundaries across the country. I think they've shied away from articulating a standard in the past. And in the intervening years, in case after case, in redistricting effort after redistricting effort, the evidence makes clear that officials don't have clear guidance on when their efforts cross a line and clearly constitute unlawful gerrymandering. The facts before the case in the Gill case out of Wisconsin, I think, present a very stark factual picture for the justices to wrestle with. Under the map drawn by the Republican-dominated legislature in Wisconsin, Republicans were expected to and did win over 60% of seats in the assembly, although they received only 48% of the vote statewide. How you articulate a standard that ensures that we have fair maps in place where votes are not wasted, where voters feel that they are truly represented, I think, is what's at stake. And, there was a rally, Ari, outside the court after the very spirited argument in this case, where a number of lawyers and advocates spoke. I spoke, but the governor Governor Schwarzenegger also spoke. And I bring that up just to say that there's growing bipartisan support for finally wrestling with and dealing with this problem of gerrymandering in our country. So I'm hopeful that the court will get there. And I think the one question is how far the court will go. Will they provide a clear, bright line, or put in place a mere gray line that helps to deal with some but not all of the controversies? But the 2020 redistricting cycle is right around the corner, and I'm hopeful that we're going to get some guidance from the court here. There's another case concerning vote purging. I'll start by just noting that this is one case in which the Justice Department has flipped positions and supports what Ohio has done in this case, which appears to violate the National Voter Registration Act, which puts in place clear parameters on when you can remove eligible voters from the rolls. In this case, officials have decided to view a voter's decision not to vote as evidence of the fact that they may no longer want to remain on the rolls. This has not been done before, but vote purging is a problem across the country. I think what the court does in this case could have devastating implications. It could put winds in the sails of people who are pushing voter suppression efforts by encouraging purging of the voter rolls. So I'm hopeful that the court will do the right thing here. The NVRA is a very clear law that lays out real clear parameters on when you can and can't remove voters from the rolls, and I think that Ohio has run afoul of that here. And then there's the Texas redistricting case. The saga in Texas around its 2010 redistricting cycle has been a long one. This is a case that has kind of bounced back and forth. I anticipate that the Supreme Court will likely deal with this case on procedural grounds. The most important thing, I think, here is the fact that several courts in the state of Texas have found that state lawmakers have acted with intentional discrimination. And so what we have lurking in the backdrop of the redistricting plan now before the Supreme Court in this case is a plan where there is evidence that lawmakers acted with the intent to discriminate against Black and Latino voters in the way that they redrew district boundaries. As we talk about the evil of partisan gerrymandering, I think it's important that we not forget that racial discrimination continues to also infect the way that lawmakers redraw district boundaries. But I don't think, Ari, that we'll get a clear rule from the court in that case.
So I think that Houston, the last case regarding Ohio's separate process for purging voters, has larger implications beyond just Ohio, as well as just the voter purge context. This is a case in which Ohio has enacted a stricter process, a supplemental process, by which individuals are removed if they haven't voted for 2 years as opposed to the normal 4-year standard. And as we noted, LDF in the amicus brief that we filed, this is going to, if the court sort of validates this process, it's going to be a signal to other states throughout the country that want to create their own more standards that make it more difficult for people to vote.
I think the partisan gerrymandering cases are going to be really interesting to me. So go into some arguments and you get the definite sets. The justices know exactly what they're going to do. They know exactly how they want to do it. That's not the sense that you got, particularly coming out at the second of the arguments. I mean, I think Kristen's absolutely right. There is a sense that a majority of the court is really troubled by this. This very much is a bipartisan issue at this point. We at Constitutional Accountability Center filed a brief on behalf of bipartisan current and former members of Congress, talking about the fundamental constitutional principle: the people are supposed to pick the representatives, not the other way around. But what the justices seemed, unclear about is what exactly to do about it, how exactly to articulate a standard. One thing that I thought was very interesting was the Chief Justice's comments at the first of the arguments, expressing concern that if the court got into this, into these waters and started issuing decisions in these cases, that it would undermine the institutional legitimacy of the court, something he obviously cares about very much. But I think the advocates in both the cases, really powerfully explain that the court has a fundamental responsibility here. It's the court's responsibility to uphold the Constitution. The Constitution prohibits the extreme partisan gerrymandering that we've seen in both Wisconsin and Maryland, and the court would be abdicating its responsibility if it didn't, weigh in and help police this.
John, is it fair to say that the court generally across different eras likes to claim it doesn't make rules, and it does, but is especially concerned about making rules that have an outcome on politics, right? You could call this a kind of a Comey-esque concern, right? That you don't know when what you do is going to capsize the election, so you really don't want to go up close to it. You could hold a press conference. You could send a letter to Congress and then another letter right before the election day. You could do that. But sooner or later, you're getting really close to the one thing you're not supposed to do. And so if you take them at their word that they really do care about that, this seems especially fraught, even though I think the panelists have just spoken to some of the overwhelming evidence of a real corruption in some states more than others of the right to vote, of whether your vote matters. So do you sense a kind of extra intense concern? Because you can't really, I'm stating a view here, you can debate it, you can't really fix this in a uniform way without setting some kind of line, and then you're making a political policy line.
I think they are absolutely on pins and needles about this. And I was struck, as Brianne was, that even after the second argument, it seemed like they really hadn't made that much progress in their thinking from the first, or at least they hadn't reflected much of a shift. They were still the same place they were, even though by that point you would have expected already a majority opinion or a proposed majority opinion to have been circulated by that point, which reflects what a hard issue it is. I mean, this is why they pay these guys the big bucks, because it's very hard for me. But the only thing I will add to all that is that there are only two opinions left from the first sitting, October sitting. Gill, the political gerrymandering case, and one of the other ones we'll be talking about soon, arbitration, and only two justices who haven't written, the Chief Justice and Gorsuch, and that isn't going to be Gorsuch's opinion, his first full term. So the Chief Justice is writing it, but who knows what that means. Rick Hasen thinks that might mean that they will say that this is justiciable, and he'll wind a course that gets 5 votes or 6 votes. With Justice Kennedy, but we'll see. It could be a mess, but it won't be decided much before June, the end of June.
And I'll just add the one caveat to that possibility, and everyone obviously is now in the tea leaves reading period of the term, is there was some speculation, I think, from Linda Greenhouse that perhaps Jesner, which we'll also talk about, which was a Justice Kennedy opinion, but only a plurality in parts, and Justice Gorsuch had a very long concurrence, that perhaps that was originally a Justice Gorsuch opinion, that he lost a majority, which would mean that Kennedy wasn't initially signed it, and that Gill could still be Kennedy's. Who knows? We'll find out, presumably at the end of the term.
We are slated to do 3 more topics. We have under 20 minutes for a lot of time, which still would leave time for some questions from the audience. So that leaves 7 minutes each, which I intend to stick to. Brianne, looking at First Amendment.
Great. So this is a huge First Amendment term for the court, and I'm going to talk really quickly about 3 of the First Amendment cases at the court that all raise claims of compelled speech. So, the Supreme Court has long recognized that the First Amendment protects both the right to speak freely and also the right to refrain from speaking. So there are contexts in which if the government makes you say something, that's compelled speech, it violates your First Amendment rights. But what's really interesting about these 3 cases is the breadth of the arguments that are being made by those claiming violations of their First Amendment rights. What we're really seeing are conservative activists, I think, trying to weaponize the First Amendment protection against compelled speech, and the implications if the court were to accept these broad arguments would be really stunning. So the first of these cases is the Masterpiece Cake Shop case. Most people are probably familiar with it. This is the case involving the same-sex couple wanted to get a cake for their wedding, went to a cake shop in Colorado, and before they could even discuss what the cake would look like, we're told, no, we don't make cakes for same-sex weddings. They sued under Colorado's anti-discrimination law, which prohibits discrimination on the basis of sexual orientation, and the cake shop said, no, this violates our right to free speech and free exercise of religion. And this is a pretty stunning argument. I mean, the Supreme Court has long upheld public accommodation laws against First Amendment challenge. The court has recognized that governments can regulate what people do. They can pass generally applicable, content-neutral regulations of conduct, and those regulations don't violate the First Amendment, simply because there may be some incidental effect on speech. So if the court were to accept, a broad argument in this case, it could have really severe implications, for public accommodation laws of all type, not just ones based that prohibit discrimination based on sexual orientation, but also ones that prohibit discrimination based on religion, marital status, race, and in contexts well outside of the wedding context. So that's case one. Case two is this.
On that case,
Yeah.
for a lot of people, it's just bizarre to have this all staked on a cake.
Yeah.
Is this the right vehicle for this issue in your view?
No, I mean, it's very odd. I mean, obviously the cake maker, talks a lot about the artistic, creation inherent in the cake. But I think, most people that go to a wedding, look at the cake, perhaps they admire it. Mainly they just want to eat it. They're not reading in, a lot of sentiments into, the cake maker. They're not, assuming that because the cake maker made this cake.
But is this case more difficult even for people who are very sympathetic to the notion of having equality protections, because at a certain point you are going to have messages that someone could ask for on a cake that they don't want to put down?
Well, I mean,
the analogy not being that it's the same, because for one thing, marriage equality is a protected right, but you could imagine an epithet or something that they don't want to put on the cake.
And, that would be a different case. But, I mean, I think it's, the important thing here is that this wasn't about the design of the cake at all. They never even got to that stage. This cake baker said, we're not going to make a cake for the same-sex wedding because we don't want to associate with same-sex weddings. And I think the problem for the challengers here is if you buy that argument, it's really difficult to draw lines. And, that's why if the court were to accept the argument as broadly as it's being offered here, it could, really wreak havoc with public accommodation laws of all kinds. And I think that's, a nice segue into the second case I was going to discuss, which is Nifla v. Becerra, actually brought by the same group that brought the Masterpiece Cake Shop case. This is a challenge to California's Reproductive Fact Act. This is a California law that requires the centers that provide services to pregnant women to post a notice just letting women know that California makes available comprehensive family planning services, including contraception, abortion, prenatal services to qualifying women, and a phone number where people can call and see if they qualify. So, here again, these centers are arguing that this is compelling them to engage in speech about abortion when they oppose abortion. But again, it's a pretty stunning argument because this kind of disclosure requirement, which just informs people of their rights and of services available to them under law, is totally pervasive in the law at both the federal and the state level. There's all kinds of notice requirements like this, and with good reason. They ensure that people don't lose out on rights, don't lose out on services that are available to them simply because they don't know about them. And here too, a broad holding in support of those challenging this law could really wreak havoc with all types of disclosure requirements that, inform people about their rights to medical privacy, their rights to, a safe workplace, their rights to continuing insurance coverage. It's a really broad argument and really fundamentally at odds with First Amendment case law as it stands now.
John is going to give us some corporate court highlights.
Okay, I have two cases in that regard. First is the Epic Systems case. It's actually a tangle of three cases. And this is another why they pay the court the big bucks, because they have to reconcile the Federal Arbitration Act and the official policy favoring arbitration contracts with the National Labor Relations Act, which says that employees can bargain collectively, or rather that they have the right to collective and concerted action. And the question is, how do those interact, and whether they should be able to engage in, collective arbitration or class arbitration, even though the court has construed arbitration contracts to say, unless they specifically say class arbitration, you can't do it. It was first argument of the term, and it set the tone for the whole term, because it was another of these cases where the Solicitor General flipped positions. And to make sure we had just enough weirdness in 2018, there were briefs by both the NLRB and the government, the United States, the Solicitor General, which is why they call it unitary executive theory. And it looks to be very closely divided. The guy who's probably the author, at least if you count the cards, is Neil Gorsuch, who asked no questions during the argument. But I suspect that probably the corporations will win that one. Second case is Jesner versus Arab Bank, which involves the Alien Tort Statute. The Second Circuit held that alien tort statute doesn't apply to corporations. That was in the Kiobel case, and the Supreme Court decided that on a narrower ground. And the court, this was just decided on Tuesday, that it does not apply to corporations. It was splintered, though. Just the syllabus ran 6 pages in 8-point type, which ought to be an Eighth Amendment violation. But as I read it, it's based mostly on discomfort with having tort claims involving foreign plaintiffs here, because the only link was really that some money came through a U.S. bank. And that the majority views the Alien Tort Statute, which was passed in 1798, for the first Judiciary Act, as a jurisdictional provision, and the plurality and the justices who composed the majority were uncomfortable with basically a common law cause of action. The way that it kind of shook out was the plurality. This was written by Justice Kennedy, said that the Terrorism Victims Protection Act, which is kind of similar, is limited to individuals, so we're going to say this is limited to individuals. Justice Alito said the whole point of the Alien Tort Statute way back there in the late 18th century was to avoid offending our allies by not having jurisdiction over these things. They didn't care a lot about corporations back then, so it's not going to offend anybody to limit it to individuals. Justice Sotomayor wrote a very powerful dissent that said, basically we give corporations all sorts of rights, see Hobby Lobby, see Citizens United, and they don't have the attendant responsibilities, which is powerfully rhetorically, but none of these, there was basically no action under this statute between 1789 or whatever and the early 90s. So, this may not have that long of a shadow, but I think it's more important probably because it's kind of burgeoning separation of powers concerns. Justice Gorsuch wrote a separate opinion on this, again talking about separation of powers. And that's it for the corporations.
I think what we'll do here, because we want to have time gathered for all the people who are here, is I'm cutting our criminal justice section, but I'm going to give everyone final thoughts, which I think is useful before we turn to the audience. So you can use your final thought for criminal justice or anything of your choosing, and also your thoughts on where we're headed here, having now digested some of these very nutritious details about what's really going on inside the court, and then we'll turn to questions. So we'll go down the line.
Great. So I'll be brief. Masterpiece. I'm thinking about Starbucks in Philadelphia and the struggle there. And to me, this is such a reminder about the history underlying Title II and why we have public accommodations laws on the books in our country that require that restaurants and hotels and bakeries make their services equally open and available to all. It's because our country has a sordid history here, one in which people have long used their so-called sincerely held moral beliefs and religious beliefs to deny services to African Americans, to people who are religious minorities. And I find the Masterpiece case to just be a reflection of that long struggle over the last few decades. I hope that the court does the right thing here, because to me, if not, it puts our country on a slippery slope where people can use religion as a basis to basically discriminate against anyone that they want. Use religion to, I don't believe in mixing of the races. It's just my sincerely held religious belief. So I really hope that the court does the right thing in this case. And I hope Starbucks does the right thing too. I mean, this I think is just an issue that is playing out in so many areas right now. My closing thought, Ari, is just about cases in the pipeline. And one big case I think that we should keep our eye on concerns the Census 2020. A few weeks ago, the Secretary of the Commerce Department injected an 11th hour question into the 2020 census, a citizenship question. And that question hasn't appeared on the census form since 1950. The census is carried out every 10 years It is constitutionally mandated, and the goal, the purpose of the census is to capture a full and accurate count of the population in the United States. That citizenship question was enacted against the backdrop of the Muslim ban and ICE raids and deportations of immigrants, and so many themes that we have touched on over the course of the past hour together. It is a question intended to discourage and deter participation among immigrant communities, among minority communities across our country. It is one that will depress participation in the census and lead to an undercount in communities. It could jeopardize our ability to fairly allocate federal funding, more than $600 billion in federal funding. There are 4 cases right now, Ari, one that has been filed by the New York State Attorney General on behalf of a coalition of states in New York, a case filed by former Attorney General Eric Holder in Maryland. We filed a case in California. The California Attorney General has filed a case. Those 4 cases are going to move, and I think will move very expeditiously because the clock is ticking. Census Day is right around the corner, and I think that we should anticipate that this struggle will make its way up to the Supreme Court next term.
My thoughts are just that the MSP's case is very interesting, and it kind of brings to a head in what may be Justice Kennedy's valedictory term a couple of things, a couple of strands of case law which are very much his legacy. One of them is very broad reading of the First Amendment, and the other is, gay rights, and the interaction of those two things. And it's probably a kind of a tough thing for him to confront. And for whatever it's worth, it looks like there's a good chance that it's his opinion. He's one of 3 people for that sitting who don't have an opinion, and it seems like the most obvious match for him. My case in the pipeline is Royal versus Murphy, which is on for the May 10th conference. A person was convicted in Oklahoma State Court of murder, and he's an Indian, and he said, that actually this area, which is Tulsa, should still be an Indian reservation, and thus he should have been tried in a federal court or a tribal court. And his death penalty was vacated and sent back for trial. It's one of the few cases where, only 15 that I know of, I have my little list here, of 15 cases where the Solicitor General has filed an uninvited amicus brief, and it'll be very interesting if they do it. Because obviously things will be very different in eastern Oklahoma if all the area around Tulsa is still an Indian reservation.
I guess, one concluding thought on this term is it's been obviously a big year for Justice Gorsuch, his first year in the court. It's been a big year for the Solicitor General's office, and I think it's been interesting to see what it has done in this year. We've already talked a little bit about how it has flipped position a number of times since the election. We mentioned in the Ohio voting case. We mentioned other contexts in which that happened. Another case in which the SG's office flipped was a case that's gone a little under the radar in this term of huge blockbusters, but this case, Lucia v. SEC, which is actually a really potentially important case. The narrow question is about how administrative law judges in the SEC are hired, whether they need to be hired consistent with the Constitution's appointments clause, but it could have really sweeping implications for the civil service writ large and how the modern federal government works. And in that case, the SG not only flipped, but really aggressively pushed the court to take the case and then to decide a question that wasn't before the court. Indeed, the court said, we don't want to decide that issue now, and the SG went ahead and briefed it in its merits brief and argued that the court should decide it anyway. So it's been a pretty interesting year from the SG. It's been called, the SG's office has been called out on a number of occasions for the number of flips that we've seen, and so I think it'll be interesting to see how that continues, to what extent it continues moving forward. And then one case in the pipeline, it's not on the court's docket yet, but could be there soon, is this case Chicago v. Sessions, a really important immigration case that was decided just a week ago by the 7th Circuit, in which the 7th Circuit held that the Attorney General was wrong and enjoined the Attorney General's attempt to impose new conditions on this grant funding that local jurisdictions receive to fight crime. The Attorney General attempted to withhold these funds simply because he and the President don't like the City of Chicago's policy toward undocumented immigrants. It was a really striking opinion, both saying that the Attorney General's action was at odds with the laws passed by Congress, but that also this attempt to do so really ran afoul of fundamental constitutional principles of separation of powers. And the Seventh Circuit really spoke very strongly about the problems with what the Attorney General was trying to do, and I think importantly, the really important role of the courts as a check on executive action like we were seeing in that case. So that's one to watch, and I think an important indicator of how courts are really stepping up in this moment and recognizing the important role that they have to play as a check on unlawful action by the executive.
Thanks so much for everybody for coming today and my colleagues and the opportunity to speak today. I'll go back to a point that I made before. If the court essentially sides with the bakers in Masterpiece and says that forcing someone to make a cake for an LGBT couple is a violation of their religious freedom, but at the same time upholds the Muslim ban, saying you can't come into the country because you're Muslim, it just doesn't make common sense. And I think at the end of the day, that's what really jumps out to me, is that we use religious liberty in strange ways. We essentially say that it applies to a cake maker, but it doesn't apply to an entire religion. So I think that is the final point that I really wanted to make. In terms of cases for the future, I wanted to highlight the variety of DACA cases, deferred action for children cases that are trickulating up through the various circuits. In addition to my work at LDF, I co-direct the civil rights clinic at Howard Law School. We have one of the cases which is in the Fourth Circuit. There obviously is a case in the Second Circuit and the Ninth Circuit as well. The government wanted the court to hear the case this February on an expedited basis, and they didn't. But again, that case is still working its way up. And for all the reasons that we've talked about here today, immigration, especially for people who are brought here when they were minors, is a particularly important issue. Thank you.
Let's take 2 questions at a time. Tell us who you are, question or comment, under 30 seconds. So you can do a comment, but it still has to be under 30 seconds. That way we'll get some people starting in the very back.
Hi, it's Ariane DeVoe with CNN. I'm just interested yesterday, the travel ban hearings, what you thought about the liberals, Breyer in particular and Justice Kagan, and the fact that Breyer and Kagan didn't at least publicly note back in December that they didn't want it to go into effect pending appeal.
And another. In front.
My name is Michael. I'm with an attorney with AFSCME, and my question, thank you. Brianne, you mentioned earlier that this court is sort of weaponizing the First Amendment. So I was wondering if your perspective on where the court is on the First Amendment in the workplace, both in the context of the Janus decision that will be coming down soon, but also in a world now where the terms resistance and deep state have become part of the culture. I imagine we're going to have more workplace speech-related cases coming down the pipe. So I was wondering if you could comment on that.
Yeah, I mean, I think Janus is an incredibly important case. It was going to be the third in my trilogy of compelled speech cases, and this, just so everyone knows, is the case that's challenging the constitutionality of fair share fee arrangements. A number of states, I think roughly 24, have adopted this model where unions are the exclusive bargaining representative for all employees in a unit, so that's members and non-members alike. And so members and non-members both have to pay the fair share cost of collective bargaining. And the idea being that if you're going to benefit from collective bargaining, better wages, better health benefits, you can help pay the cost for that. And here again, we're seeing basically a compelled speech claim, people challenging these arrangements, saying it's compelling them to associate with the union and support the union speech. And again, it's a really stunning thing to be seeing. The Supreme Court held over 40 years ago that these arrangements are constitutional. And the reason why we're seeing this issue at the court now is because conservatives on the court have really strongly encouraged activists to bring the issue up, signaling their disagreement with that 40-year-old precedent. Justice Kagan, in dissent in one case, pointed out the majority couldn't refrain from saying how much it disliked that precedent and saying it over and over and over again. I think it is. This was a case that was actually at the court a few years ago in Friedrichs. It was one of the last arguments that Justice Scalia heard before he passed away, and the court that term split 4-4. That leads everyone to assume that Justice Gorsuch will be the key vote. He did not say much of that argument either. Certainly I think there's reason for concern given the pro-corporate tilt that we've already talked about from Justice Gorsuch. But that's a hugely important decision and one that everyone should be watching come the end of the term.
So the court's liberals, Justice Breyer was very interested in the waiver provision of the travel ban, essentially whether or not it was real, whether or not people can actually get around the bans that have been imposed for each individual country. I thought actually Justice Kagan made one of the best points of the entire argument, which was essentially saying if we took everything that has been said about Muslims in this case and applied it to Jewish individuals, and then after that, imagine that the president had imposed a ban on individuals from Israel, would this still be constitutional? And really, the Solicitor General's response was very, very interesting. He certainly, tried to distinguish that potential hypothetical, but his main way of distinguishing it was not very persuasive. He essentially said that would never happen. And so I thought Justice Kagan and the response from the Solicitor General were very telling.
And I guess I'll just quickly say that one thing that gets lost in the controversy surrounding the Muslim ban is the fact that there are real lives being impacted, that there are people in war-torn countries, that there are people facing oppression in their home countries who are seeking refuge, who are seeking support, who are seeking medical assistance, who are seeking to enter the United States and reconnect with families and get the help that they need. That human piece of this debate, I think, often gets lost. And so I'm thankful for those justices who remind us what's truly at stake in this case. There's so much focus on the animus, which seemed to have informed the Muslim ban, so much focus on the broadness of the president's powers and his ability to protect national security that I think we sometimes forget that very important piece, that there are folks like our client, a 10-year-old girl with a life-threatening illness who wants to reconnect with her father who is a U.S. citizen. And the administration can tout its waiver option and other features of the Muslim ban. At the end of the day, it is a policy that outright prohibits people from entering this country from several predominantly Muslim nations. It's arbitrary, it's capricious, and my hope is that the court strikes it down.
And it's 150 million people. I mean, Justice Alito tried to make the point that, we're only talking about, quote unquote, 8% of the Muslim population. I mean, that's cutting the pie in a strange way. We're still talking about 150 million people being affected.
I thought the waiver part of the oral arguments was the weirdest part, just because it's like, either you can do this thing or you can't. If you can do it, then whatever. And if you can't do it, then the fact that there's some waiver cutouts doesn't really rescue it. It just makes it sound like maybe it is a bad thing, right? I mean, if you pick the most extreme example of national origin is, it seems, flatly ruled out by the Immigration Act. But a small splinter country wages war on the United States, and the president, in response to that on a national security basis, bans from that country, it would seem that that would be potentially executive authority for national security. The court's unlikely to at least second guess it in real time, and I don't think a waiver would save it, right? It would be that you actually have that authority. I thought that whole part of it was really odd. More questions?
I'm Greg Storr with Bloomberg News. Could you all just talk about the prospect that John raised that it might be Justice Kennedy's final term?
Hold up, just so everyone can get back in here.
Just talk about the prospect that it might be Justice Kennedy's final term and just how worried you are about that prospect. John, you may not be worried, may not be the right word for you, but the others, I suspect.
Wait, we're going to do one.
Down if you can leave the court.
We're going to do, I like to get more than one question so we get multiple. Anybody else have a question? Over here?
I'm sorry, where did you point? Okay,
Jennifer Pizer with Lambda Legal. So this is a question about Masterpiece. If the decision is written to allow speech or religion exemption to civil rights law, obviously the implications would be enormous. But if it's written to say race is different and sexual orientation or sex, can receive different treatment, as we kind of saw in Hobby Lobby, at least in the majority, then maybe it's narrower. And so I'm just interested in any thoughts that you have about which way things might go, not in terms of which doctrine, but in terms of whether that limitation might be made.
So Justice Kennedy's potential departure, which I know Elizabeth was also speaking to in her opening with regard to the clerk hiring, if you want to read those tea leaves, and this question on the cakes.
So the average retirement age for a Supreme Court justice is 81. Ginsburg is 85, Kennedy is 81, Breyer is 79. It's concerning.
I don't know, Justice Kennedy probably doesn't want John's, private sector value to go down. So that may be reason enough. I mean, I think, as Elizabeth said, it is difficult to imagine that Justice Kennedy would think that anyone else would be a better steward of his legacy on the court than he himself is. And, particularly given that this president, promised that when it comes to Supreme Court justices, he's going to try to nominate justices who will make evangelicals happy. I would think Justice Kennedy, who has crafted such a legacy on LGBTQ rights, on abortion, I would think that he'd be, pretty nervous about leaving his legacy in President Trump's hands. And as Elizabeth pointed out, he has hired a full complement of clerks. So, that doesn't necessarily mean that he's not going anywhere. I'm sure those clerks will be fine if he decided to retire. But I think it's a pretty good sign that at least when he made those hiring decisions, he wasn't planning on going anywhere.
And I feel the same way about the possibility of a vacant seat on the Supreme Court as I do about the way in which this president has been handling nominations for vacant district and circuit court seats generally. We have seen deeply troubling nominees put forth by this president, nominees who harbor open bias towards the LGBT community, a nominee who blogged support for the KKK, a nominee who had little trial experience, little experience appearing before federal courts, little knowledge of the federal rules. The quality and caliber of nominee under this administration has been frightening. And I worry that this, once we talk about the Supreme Court, has the potential to erode the integrity of the Supreme Court. We've seen the Senate moving at lightning speed in how it handles and reviews nominees. They're not properly vetting nominees. So I think we have to look at the bigger picture here and be deeply concerned just about how nominations have been handled generally, and can't forget that this administration is turning the clock back when it comes to promoting race and gender diversity on our nation's courts as well.
You're talking about how the administration approaches vetting for judicial nominees?
In general.
Do you think that they should more look to the approach they've used to vet cabinet nominees? Would that be a different model?
It's a devastating picture all around.
It's just, you have to think about vetting. We'll take, I think, 2 more questions maybe, or 3, and then we're going to wrap up in respect of the timeline we proposed to everyone.
Elliot Mintzberg with People for the American Way. Everybody knows there are 2 grounds on which the bakers in Masterpiece are trying to claim the public accommodations doesn't apply to them: freedom of speech and freedom of religion. As between the 2, I'm interested in the panel's view as to which of those arguments you think is stronger or be more likely to be accepted, we hope neither one, by the Supreme Court.
Okay. Here.
Thank you. I'm Aaron Fisher. I'm a grassroots organizer, so kind of out of place here. But my question is about gerrymandering and kind of the inadequacy of the pace of the courts. We're settling gerrymandering for districts that aren't going to exist very, very shortly. Is there any kind of likelihood that the justices will decide these gerrymandering cases in a way that won't just lead to another 10-year cycle of cases going back and forth and, people in Greensboro and Austin and other places not being represented fairly?
And anything else we want to get? Anyone else dying to ask a final question? Then we'll make this answers as well as anything else you want to say as we wrap up what has been a very interesting set of discussions.
Yeah, I'm deeply concerned about the upcoming 2020 redistricting cycle. I think the Supreme Court took 2 cases because I think they are prepared to articulate something more than what they have in the past about what constitutes unlawful gerrymandering. I don't think we're going to get a bright line. I think we may get something gray that helps to deal with perhaps the most extreme forms of gerrymandering, and I think the fact pattern out of Wisconsin that is now before the court presents an opportunity for the court to put in place a kind of gray line that deals with the most egregious and extreme forms of partisan gerrymandering. That said, we can't forget that racial gerrymandering remains a threat as well. My final point would be that we shouldn't look to the courts fully for the answer here. I think it's incredibly important that the public pay attention to redistricting, that takes place in their community at the local, state, and federal level. Engage in the process, engage with officials, push back where they believe they are crossing the line. I don't feel confident that the court by itself can resolve the complexities and challenges that we face when we engage in redistricting at a granular level around the country.
For what it's worth, I think Masterpiece Cake Shop, the claim is much better on the speech side than the religion side since Employment Division versus Smith. But who knows? Who knows? It may be a very religious, I suspect it would be a very religious themed free speech claim.
To the other Masterpiece question, I mean, I think it's, I think what the court will find if it tries to kind of carve out race or say race is different is that's a very difficult line to draw. I think one thing that we saw at argument was some suggestion that Justice Kennedy in particular was very concerned about, comments that had been made by individuals in the Colorado Civil Rights Commission. So I think if the court, is trying to craft a very narrow decision, that may be where they end up going. But I think that highlights an important point about that case, about NIFLA, about many of the cases we've been discussing, which is there's this temptation when the cases come down to say who won, who lost. But what's really going to be so important in so many of these cases is how that person wins or loses and how the court writes the decision, what the reasoning is, because that's going to tell us a lot about the implications of the court's decision and whether it really has broader implications than that particular case. And then one other case I'll just flag very quickly because we didn't get to it is Carpenter, which is a really important Fourth Amendment case the court's deciding this term about whether the government can track an individual's location using their cell phone without a warrant. And I think we've talked about a lot of hot-button cases this term that will probably break down 5-4, probably on, or at least possibly on ideological lines. That's a case, I think, where we could really see the entire court coming together in support of a robust understanding of the Fourth Amendment's protections, as we've seen from the court in recent years. Although the question there, too, will be how exactly do they do that? And that seems like something that we're wrestling with at argument in that case.
Yeah, and thank you for bringing that up, Brianne. And that's a case in which an individual was tracked for 127 days. So it's the idea that, yes, when we go out into society, we expect that we lose some expectation of reasonable privacy, but we don't expect that all of our movements will be tracked for 127 days. Back to the Masterpiece question, I think the reality is that anytime someone goes into society, they have to give up some of their rights. Otherwise, we'd essentially be living in sort of a caveman state. And part of functioning in a multicultural, diverse society is understanding that. And I think that, the freedom of speech, our argument would be stronger if it wasn't essentially making a cake. If it was somebody actually exercising speech in a more traditional way. But I think those two things taken together, the fact that, this is somebody making a cake at the end of the day, and second, that, part of functioning in a society that's diverse and multi-ethnic and multi-religious is compromising some of those values. Thank you.
In closing, I'll just mention that we've now spent 2 hours without talking about tweets or Kanye West or, President West. Although Donald Trump president jokes used to be a big punchline until they became our lives. And I think that speaks to something that in a time of real profound concern about where the country's going and whether our political processes are working and whether our civil society is healthy, the Supreme Court really is still a very serious, substantive, merit-driven place to work through our issues. And you see that in the panel we've assembled, in the oral arguments, in the seriousness that the court sets a standard that people around it, I think, reflect. And that is something that's a testament to our founders and our Constitution and parts of our republic that are not so easily eroded or chipped away, even in a time of, I think it's fair to say, sustained civic stress as this one is. So perhaps that's a nice thought to think about why this was hopefully, we hope, worth your 2 hours of valuable time. And our thanks again to Elizabeth and the Constitutional Accountability Center and everyone represented on the panel. And thank you. And as the old, there was an old song by the Oak Ridge Boys that also was used by the rapper Fabulous, which said, "You ain't got to go home, but you got to get out of here." So thank you for being here.